Good afternoon and welcome to LIBOR's Wednesday webinar. My name is Marianne Monteleone, Vice President of Education Services for LIBOR. Today we have, this month, let me preface it with, this month is legal month, and because of all of the talk about buyer agency, the changes that may come about to our great profession, we have dedicated every Wednesday webinar to that subject, and we have a very special presenter with us who is no stranger to LIBOR, Roseanne Farrow, to talk about buyer agency agreements and the importance of that. Let me formally introduce our friend, and then I'll turn it over to her. Roseanne Farrow has been with 40 years of real estate sales, training, management, and consulting. And she personally has trained and coached thousands of real estate agents, managers, and brokers who are lifted by her passion, humor, high energy, dedication to the industry. A Realtor Emeritus National REBAC trainer, and a senior instructor at NYSAR. She provides independent training, course development, and consulting nationwide as Roseanne Farrow seminars. She instructs a plethora of national designations, courses, and is a New York State subject matter expert for the CE Shop. Her programs enhance productivity, quality, and profit, and include risk reduction tips and tactics that add value. Originally from Long Island and a longtime friend of LIBOR, Roseanne raised her family in the mid-Hudson Valley's Cornwall on Hudson and now resides in nearby town of Newburgh, 60 miles north of Manhattan. Her greatest accomplishment is her family, and her greatest strength is her sense of humor. And I turn it over to our friend, and we're so happy to have her with us, Legal Month on Buyer Agency and Agreements, Roseanne. Before we do, if I may just take a moment to read a very important statement for this session. The rate or amount of commission charged for the sale, lease, appraisal, or management of real estate shall be negotiated between each member of LIBOR and their client customer. Furthermore, all LIBOR education courses and webinars must be conducted in full compliance with antitrust laws. There shall be no discussion of any topic suggestive of an intent to restrict competition or fix prices, including commission splits, broker compensation, or company policies, criticism of another company practices or any particular business model, or excluding from membership or participation any specific business or businesses that practice a particular business model. If any such discussion occurs, the staff monitor or instructor will end the discussion or the course immediately. And we thank you for your cooperation. So without further delay, we turn it over to our friend Roseanne.
Thank you, Marianne. Thank you so much. Welcome, everyone. If you are having trouble seeing the screen, I would recommend you go to speaker view so that you can see a big screen. And then when someone is speaking, we'll be able to see you. Back to the title, Buyer Agency Agreements, Understand and Know the Importance. You know, I had a bunch of different titles, so I'm just going to show you that I was going to call it Buyer Representation Best Practices, and I did write that little 3-hour course, and a lot of companies are running it. Protect your rights, protect your fee. Those are kind of the buzzwords for all of us right now. And then, of course, there's another title I offered to some boards called Protect Your Rights and Your Fee with a Buyer Representation Agreement. I think we've all come to the point, let's hope, that we understand the importance of doing things in writing, not just because the Code of Ethics, Article 9 tells us we need to do that, but because it just makes sense, right? So here's my important caveat at the beginning before we jump in. We all took the salesperson licensing course, whenever we took it, whether it was 45 hours, 75 hours, 77 hours, always in that course, we learned this, what you're looking at on my screen. In New York State, there are only 3 kinds of agency agreements that we are allowed to have with any principal, buyer, seller, landlord, tenant, and these are what they're called. The open listing. So let's go to something you all know, sellers. You've been all listing houses for years. You all get that. So you list a house with a seller and it's an open listing agreement. That means the seller can sell it himself without worrying about you. You can have this open, the seller can hire 10 different companies with open listing agreements. It's like the Wild West, right? Anybody can do whatever. That's the open listing. The MLS will not accept an open listing because they can't put like 20,000 of them of the same house in the MLS at the same time. So they only accept the next two for the MLS. But legally, open is a legal kind of agreement. Exclusive agency is the one, let's stay with sellers, where when the seller hires you exclusively, the seller reserves the right to sell the home on his, her, or their own without paying you. But you, the real estate company, you get the listing, you put an MLS, etc. All right. So the exclusive agency is the agency agreement whereby the principal, the seller in this case, has the right to still do it on his own, competing with you generally. The third one, and the one that most people talk about, and not that we all got together and agreed that to do that, but it just seems to be the most popular, is the exclusive right for sellers. It's to sell, right? It's called, when you list a house, it's not called exclusive right to represent seller. They just didn't name it that years ago. They named it exclusive right to sell. I don't know why, but that's what they called it. So exclusive right to sell is the agreement you fill out and complete with the seller's informed consent when you list the property. You put that in MLS, generally you would do that with informed consent of that seller client, and that's the listings that we all kind of are looking up all the time. But when it's an exclusive right with a buyer, it's called exclusive right to represent. I used to be an English teacher, so I get hung up on words. So to me, when they first called it exclusive right to sell with the seller, I wondered why later they didn't call it exclusive right to buy with the buyer, but they didn't. New agents sometimes get that mixed up. If they had changed or agreed to change the seller name, then they could call it exclusive right to represent seller or exclusive right to represent buyer. But it is what it is. And agents, especially the new ones, just so it's clear, there are 3 different ways we can have agency agreements. When you have an office exclusive and you call it that, that's not really one of these. What it is the exclusive right, but you didn't put it in MLS because the seller didn't want you to. Okay, but it's still an exclusive right. All right, so these are the only 3. I hope that's clear so we can move on. So let's move on to my opening slide. Raise your hand in the air. I can't see it, but raise your hand in the air if you've ever had an exclusive listing contract with a seller. I'm sure there's a lot of hands going up. Now, raise your hand again if you've ever had an exclusive buyer representation contract with a buyer. Now raise your hand. If I could see you all, I would guess there are fewer hands up right now. So we need to get back to some basics. Let's face it, some of you take designation courses, you know this. CBR, Certified Buyer Representative, and ABR, Accredited Buyer Representative, take 2 days. We only have 1 hour. So we got to jump in and get back to basics. And you know what, my friends, every now and then, it's good to get back to basics. And in many business schools, when they talk about basics and teaching basics, the same name always comes up, even though it's from the 60s, and it's Vince Lombardi. Now, some of you remember old-time football. Some of you never heard of it. But in around July 1961, this gentleman, Vince Lombardi, who's one of the most famous and often used sports quotes in history, said this to his team. He came on board, for those of you who want the history, he came on board with the Green Bay Packers, who were like really not that good of a team in 1961. They were not winners. So he got recruited and came on board, and he said, okay, guys, he said this actually, gentlemen, this is a football. This is a football. These are the yard markers. I'm the coach. You are the players. And every now and then, it's good to get back on to basics. So what he did with this team is these experienced players, he opened up the playbook and he started on page 1, and they had to learn, the fundamentals: blocking, tackling, throwing, catching. It's not what they expected. But you know what happened as a result? He took this team to championship. The lead in the NFL in the leagues. He never lost a playoff ever again. They won the NFL champion that year, 37-0 against New York, the New York Giants. And he went on to win 5 NFL championships in 7 years, and he never coached a team with a losing season after that, and never lost a playoff game. That's why we have to pay attention to getting back to basics. So let's do it with real estate. Join me on my screen. This is a seller, Sam and Sally, somewhere in New York. They hire you to get their home sold. You take an exclusive right to sell listing. They're your client. That's the one you happen to take. They're your client. They're loyal to you. You get paid if they sell. Now, let's move to buyers. This is a buyer. They hire you to find them a home. You take an exclusive right to represent listing. They're your client. They're loyal to you. You get paid if they buy. So let's compare. As you can see on the screen, to the left, we have the seller. To the right, we have the buyer. Take a look. You know what? It's the same thing. So what is the problem? Why? And I'm an instructor all the time in this buyer agency piece. I teach a lot of courses, but agency is such a big one. I teach it a lot. What's the problem? Why is it that for so many years since we've been practicing buyer agency, now it was always in the law of agency, and that was created in 1922. However, we kind of didn't really pay attention to it. We all traditionally represented our sellers. The sellers were the client, the buyers were the customer, and we moved on with our life. We always could have represented buyers. Our commercial groups always did. However, we didn't, so whatever. But then we started doing it. We started representing buyers in around year 2000. We started doing it, representing them, but there was a pushback. The seasoned agent said, I don't want to do it. I'm fine how I am. Leave me alone. I got this. I already have buyer loyalty. They have all these reasons they didn't want to do it. Other agents just didn't get it, and they didn't understand how to go through the contract. They stumbled over their own words. They were like, humma. They didn't understand how the buyer would ever agree to paying or being responsible to pay the agent. So a lot of them just said, I don't think so. And they just didn't do it. And then as we got more and more into buyer agency, some of you, and I think a lot of you still, would take out the agency disclosure form and then write it up as agency, working in the interests of the buyer as a buyer's agent, and go out and show houses. And you know what happens? You know what happens when you just do agency disclosure? I'll just hold it up so everybody remembers what I'm talking about. Agency disclosure, right? The agency disclosure. When you take agency disclosure, which I hope to God you're doing at first substantive contact, when you do that and you fill out agents of the buyer, represent the interests of the buyer as a buyer's agent, and then just run out and show houses, you just took, by default, an open listing on your buyer. You took an open listing on your buyer. And then that means the buyer can still go out with other brokers. The buyer can buy a house on his own. The buyer can be a free bird. He can just be a free bird. And if you're comfortable with that, with open listings, and your broker is too, I'm not here to judge you about that. I'm just reminding you that you have now given up the exclusivity opportunity that you maybe kind of should have, could have had if you had taken out an agreement and had it in writing. So at the very least, I caution you, if you're going to keep doing open listings on buyers, I recommend that you take that you invent one. Your lawyer would do that, not me, and not you, but an attorney would create an open listing agreement, so you'd have something in writing. And I have an old-time name from LIBOR to back me up right now. And I'm holding up, Mary Ann's going to laugh when she sees this, because I have a copy from the 2005 July-August newsletter called The Realtor from LIBOR in the day. And it's the attorney who was your attorney, Howard Goldson, passed away now, rest in peace. He wrote an article, and I'm just going to reference it. He said, don't be a buyer's broker unless you have a buyer broker agreement. Now, he didn't say it had to be exclusive. He just said an agreement. And he speaks about a case that really happened in Long Island. It went to the Nassau County Supreme Court, and here's what happened. The buyer's agent from a brokerage in Nassau County had a buyer client, did agency disclosure, said that she was a woman. She said, I will be representing the interests of the buyer as a buyer's agent. No other further paperwork or whatever she had in the buyer packet, but she did not do an agency. She did agency disclosure, but not an agreement in writing. She takes her buyer out, shows homes. The buyer finds one that she loves. The buyer makes an offer on the property, but doesn't get the house. Why? Because another agent sold the house. It was a better offer for whatever reason. So this buyer was out of luck. So the buyer was kind of annoyed about it. So what did she do? She sued the broker who did not sell her the house because she dug around and found out that the house that she lost, the buyer, was sold to another buyer through the same company that her agent was working at. So she hired a lawyer and they went for it and they sued for breach of fiduciary. In other words, how dare you, Mr. Broker, how dare you allow another agent to sell the house that I wanted to buy when you were representing me in my best interest? You know what happened when it went to Supreme Court? The judge ruled in favor of the plaintiff and said to the agent who didn't make the sale, the judge did his homework and he held up the exclusive right to represent agreement, because that's the only agreement you guys had at the time and still have, and said to the agent, do you know what this is? It was the LIBOR agreement, which you still have on Docs on Demand. I'm going to show it to you on the screen in a minute. You know what this is? And the agent said, oh yes, it's the representation agreement. And the judge said, did you show this to the client, and she said, no. Well, why didn't you? I don't know. She didn't know why. So the judge said, well, if you had, your client would have seen the other potential buyer clause, that clearly says buyer understands and agrees that broker may have more than one buyer looking at same or similar properties. And then the buyer would have no reason to be here today, would have no right. So when your attorney for LIBOR, Howard Goldson, heard about the case, he was like, oh my God, you guys, you got to start using in writing representation agreements, whether it's open, whether it's exclusive agency, whether it's exclusive right. Put things in writing, just like you do with your sellers. And that's really my key message for you today. But let's go through some more of the pieces to this, all right? I believe also the problem why many of you are not willing to pull out the form, even though I hope it's in your buyer packet, you're scared to pull it out. And I believe because it has to do really, now I'm not Dr. Phil here, but let's face it, it has to do with psychological things. It has to do with the dynamics of change. When we ask anyone to change how they do things, it's not fun, because change I just made this up, so it's my course. So I believe there are 5 dynamics that fall into play here. One is that change is uncomfortable. We don't like to do something different, and people like to be comfortable. People like comfort. People like familiar things. Also, change is scary. I mean, not ooh scary, but scary, you're afraid that it's not going to work out, and your attitude jumps ahead and you say, oh, well, what if this? What if I don't get it? And you get fearful. And fear and doubt are your worst enemies, right? Our doubts are traitors, as Shakespeare said. And our doubts are traitors and cause us to not have the good we might have had. Our doubts are traitors. So we don't want to have doubts. It's scary to have doubts. It stands in our way. And feelings are not always facts. You might have a feeling like, oh, well, my buyers are loyal, but it's not necessarily a fact. And you own those. You own your own thoughts. You own your own feelings. You own your own paradigms, the lenses through which you see your world. You own them. And if you own them, you could change them because you own them, right? You own them. So to say a buyer will never sign the agreement, first of all, it's not true. We have facts on that. But if you own that thought, Then number 5, your behavior will follow because your behavior follows belief. So let's look at that exclusive right to represent agreement. I have the LIBOR one snagged here on the screen for you. It's the exclusive right. There's not an exclusive agency one that I could find, and there's not even in my board, and there's not an open one that I could find in writing. Although, as I work with different brokers, like individually for their companies, private stuff, a lot of them have created their own. I don't know what your broker has created, and it's not my business to know unless he hires me. But please go back to your broker, or if we have brokers here today, take another look at the different forms that you have so that you can be prepared that if someone doesn't sign the exclusive right, you'll at least have a fallback of the exclusive agency and or the open, so that you at least will have some kind of rules of the road in writing. These agreements signify and codify the rules of the road, what you can do, what you cannot do, what I can do, the buyer, if I'm the buyer, what I should be doing, what I should know, and what I should not expect from you, because let's just say like the engineer or the home inspector, I'm not, the real estate agent's not the inspector, so the buyer should not expect that. But if it's not in writing and everybody sits and discusses and you have a conversation like you do with sellers, you would less likely be sued by a buyer, because you sat down and had the discussion, you had the conversation, you had the buyer consulting session like you do with sellers. So let's take a look, though, what comes before the representation agreement. That's why I said, but first, let's talk about the disclosure form. I know that there's some of you, and I'm sad to say this, but I know it's true, that some of you are not really following the law, Statute 443 of the Real Property Law, which states that you must, not like if you wanna, but you must discuss the agency disclosure form with your customers and your clients. This is the buyer and seller one, but there's another one for landlord and tenant for my folks who do that kind of business. That's fine. And we now have them in lots of different languages. We have them in Spanish, Russian, Korean, Italian, Chinese, and Haitian Creole. The DOS came out with them about a year ago. So if you don't know about that, find out and then check with your broker if you are going to be offering them in other languages. This is the one in English, obviously, and it does codify the relationship that you are trying to make with informed consent with that consumer, whether it's a customer or a client. And of course, when I say codify, I mean that moment in time in writing. But quite frankly, your behavior is really the proof of the pudding. If you take someone on as a customer, but treat them like a client, you tell them what to offer, you give them tips on, information that's confidential with sellers that you shouldn't be doing. If you're doing that with customers, then you are a buyer's agent. And most likely, if you're showing in-house listings, now it's really big trouble, because now you're involved in undisclosed dual agency. If you treat a customer like a client, looks like a duck, acts like a duck, it's a duck. You need to understand that. I'm going to get to some of the questions in just a bit, okay? So bear with me, my friends. This is the agency disclosure form. And you see this section right here? Seller's agent, buyer's agent. Let me blow that up a little bit for you. This is what teaches, if you will, the consumer what the responsibility is. Like, say you list a house, if you're a listing agent, then you're a seller's agent. You could be a seller's agent in other ways too, but let's stick with you listing a house, you're a seller's agent. You're listing a buyer, you're being hired by a buyer, you're a buyer's agent. And in these both boxes, let me make them bigger, you'll see that it does mention the forthcoming agreement that you're too chicken to pull out with the buyer. So here for the seller, the obligations of the seller's agent are also subject to any specific provisions set forth in an agreement between the agent and the seller. What agreement when you list? The listing contract. You do that all the time. You're used to it. You don't take it out of the folder, being the seller's folder, saying, oh, what if they don't sign it? Oh, I'm so afraid of it. No, Even in the disclosure form, it mentions that there will be a forthcoming agreement. Now let's jump to buyer. The obligations of a buyer's agent are also subject to any specific provisions set forth in an agreement between the agent and the buyer. It clearly is stating in the agency disclosure form to a buyer client, get ready, pal, there's something else coming. I believe that the representation agreement is just an extension of the agency disclosure. And that's kind of how I do it. I mean, I have a real estate license and I sell real estate, not a lot, but I still do, but I certainly did my early career. That's what I did. So I think that when you have your agency and then you agency disclosure, and then your exclusive right to represent, I'm holding the LIBOR one, that to me, they're like, to me, this is page 1, this is page 2. You know what I mean? So to me, I don't have a lot of trouble with it. I'm comfortable with it because I've gotten used to it. And you would too, because I'm not even anybody special. If I could figure it out, so could you. To me, when you're sitting with the people, the buyers, and they choose representation so that you will be working for them, if they stay customer, you're only working with them. But when they hire you and you are their advocate and you are a buyer's agent, you are working for them as a matter of commitment. So I'm working for them as a matter of commitment. They choose that, complete this form, agency disclosure, bingo. I just take out the next piece. Okay, so now let's talk about the rules of the road and how it works. That's how I'd introduce this. Let's review this together. And they may say, oh, I don't want to sign anything, or I don't want to pay you. Or they may say that, and it's fine. Fine. That's fine if they don't, because it's America. They could do that. But let's at least cover the rules of the road so there's no misunderstanding, Mr. and Mrs. Buyer, or whoever they are, of what the rules of the road are, so that we don't have any conflict. You know, I'm working for you as a matter of commitment. I become your fiduciary. I owe you the way your attorney is your fiduciary, the way your accountant is your fiduciary, so am I. And when you hire me, it's a very serious legal commitment, because I owe you the fiduciary duties of obedience and undivided loyalty and full disclosure of more than material fact and confidentiality. And in New York, it's forever, not just for now, and accounting and reasonable care and diligence. These are serious legal requirements, on me when you hire me. So yeah, I want to have something in writing, some kind of a discussion about it at least. I hope that makes sense to you, my friends, today. I hope it makes sense that you want to have something in writing. In fact, let me ask you this. If you were going to lease an apartment month to month, just month to month, wouldn't you at least have something in writing, even though it's month to month? Yes, because you'd want to know the details, like what constitutes, a guest, and how long can I, how many people can I have there, or can I have 2 pets or 3, or all the stuff you'd want to know in writing. That's what this is doing. That's what Howard Goldson, the attorney years back, wanted you to do too, to have it in writing so there's no misunderstanding. It's not just because you want to get the money. It's because you want them to understand the other potential buyer clause, and that you're not an attorney, and that you're not a town supervisor. And are you going to go and pull the property card or the FOIL report? I don't know. That's got to be discussed with your informed consent and agreement. But at least think about using this kind of a form that will help everybody to figure it out. So let's see here. Is buyer agency agreement, here's the question. Is the buyer agency agreement and buyer broker agreement, is that the same thing? That was Joe asking that. It could be called many different things, but it would state, I hope, on the top of it what it is. Like here, this one says at LIBOR, but exclusive right to represent, and then in parentheses, it says buyer or lessee broker agreement. So it depends what your group is. Joe, I don't know, maybe your broker has his own at your company, maybe, or you're using LIBOR. So the buyer agency agreement and the buyer broker agreement could be the same thing. However, if it's an exclusive agency, not an exclusive right, that would need to be clarified. So I don't know exactly if it is in your question. Okay. So what else? Let me see what else I'm looking at here. Is it possible to be shopping for a home as an agent and still get paid a commission for the purchase? So the question I think is from Kevin, if you're an agent buying a home, can you still get paid a commission for the purchase? I think if that's what the question is, so I can clarify. If that's what it is, then let me address that. You need to talk, Kevin, to your broker. When you were hired, there's policy and procedures. So there would be something that this would be something you ask your broker at the get-go. What if I want to buy real estate? Do I earn a commission and do I get paid? Find out what the broker's policy is on that and how it works. I know I was a manager for many years and for a company in the Hudson Valley, and we had all of that listed in the policy manual. So I don't know what your policy is, okay? So find out. Let's see. Good day, it says. If they refuse to sign, saying they're not sure if they're going to use you as the agent, should I still show them homes as a customer? Again, this would be not for me to advise you because I'm not your broker, but ask your broker if that's what the broker would recommend. Remember, my friends, your broker is your principal and you're his or her agent. So you have a fiduciary to them, right? So your broker sets the rules of the game. If your broker says, at this company, we're only going to represent buyers as clients, not as customers, I don't know what their rules are, then follow what they say. But if they wish to remain customers and it's okay with you, then I guess you could be a sub-agent in the MLS, because in Long Island land, they still allow a lot of that. I mean, I say Long Island land because, see, I am in your MLS, but I'm not in your counties that cover. I'm in the upper state, if you will. I'm in the Hudson Valley, and we have the Hudson Gateway Association of Realtors, and you are in the Long Island Board of Realtors, but we share the same one key MLS. So in my area, we are only buyer agents if we want to show other brokers listings, because that's the only way we can get in. In your area, I see, because I've seen, like I teach for you all the time, I've seen that a lot of brokers offer sub-agency in the MLS. You can go in with a customer to their listings. A lot of them offer broker agency in the MLS. You can go in with a customer to other brokers' listing, but relieve the seller of vicarious liability. And they offer, some of them, buyer agency. Now, when I say they offer it, they have to offer it, but they don't have to pay. So let me be sure that you're clear on this. The Department of State Division of Licensing says that all buyers, since they're consumers, have the right, buyer clients have the right to see the other listings in the MLS. The listing broker must not disallow cooperation, but they don't have to offer compensation. So if you want to show a house, to your buyer client, and you call up the other broker's company and they say, oh, we're not really co-broking right now. And, we're just going to keep it in-house for whatever they say. They say all crazy things. Okay, whatever they say, then you could respond or have your manager call them and say, I know we have the right, according to the Department of State, to show the listing. So we'd like to show it. Maybe they say this Saturday or would Friday be more convenient, whatever they do. And they make the appointment. And then they say, and if you're not offering compensation, we understand that, but let me ask, are you? But if you're not, I understand that. And then you have to figure out, we'll get to that in a sec. We only have an hour, remember, how you're going to get the money. So they must offer cooperation. Make sure that you understand that. And you know what? The DOS cannot force the seller to let you in, because the DOS has no power over sellers. They only have power over the licensees. So if the seller still says, no, damn it, we're not letting them come in, I only want your company, then the listing agent has to cancel the listing. That's a DOS rule. So I want you to be sure of that you can get in. Now, let's see. Oh, Mary Ann's reminding us that LIBOR has created a new page on our website that has many helpful resources for the members on buyer representation, including the agreements. And she put the link right there. That's awesome. Now, Joe is asking, are you saying that agency disclosure and exclusive right are the same? No, Joe, of course not. They're not the same. Agency disclosure is this, right here. This is statute 443 of the law of agency of real property law. And then, oh, sorry, I'm doing the wrong form. Sorry, this is agency disclosure, right? This is the law. And then having something in writing, when I say it's page 2, I make them to be like partners. I move from agency disclosure with a buyer client right to this form. I just move to it. But no, if they sign this, which they hopefully they do, and then if they don't sign this, that's their option, because they have the right to agree or not to agree. Remember, these are always with informed consent. Okay, I hope that clarified that. All right, let me just move on, because remember, we only have a little bit of time. So here's what I hope this was helpful to you. In fact, write in the chat box yes or no if you already knew this and it wasn't helpful. Write in the chat box yes if this was a good thing that you realized by looking at this. Write yes or no in the chat box, because I want to know that I'm doing the right thing. A lot of people are saying yes, and I appreciate that. Yeah. So I hope I've helped to allay some of your fears about pulling out that form. Here's the representation agreement from LIBOR. And, you know, like Einstein said, take a picture of this. It's good to know this. If you can't explain it simply, you don't know it well enough, right? Come on. So you look at these forms and you go, oh, blah, 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 blah. What does it even mean? It's all legalese. It makes me crazy. What do I figure out how to understand it so that you can then, pardon me, paraphrase it in your own words, making sure you hit all the fine points and explain it thoroughly. But if you don't understand it, how can you? And let's face it, my friends, if you pulled out right now, don't do it, but if you did, if you pulled out the listing contract, you'd want to blow your own brains out all over again, because it's the same kind of thing. It's like, what? But we all got used to it. We learned how to understand it. We learned how to paraphrase, if you will, so that we can help the seller client to understand what it says. We got used to that. And if you're laughing right now saying, well, I don't know, I never got used to it. I just don't even cover it. I just tell them to press hard 3 copies. Well, then you're blowing it, because you're doing it the wrong way. You need to be able to work with these clients with their informed consent, so they understand what the heck is going on. So here's the top part, right? Here's the top part. Date. I mean, it's pretty easy, right? Who residing at, that's the clients, and then you. And then the exclusive employment part, they agree to work exclusively with you. They're not going to go to other brokers. I kind of think of this as like they hire you, and maybe they don't sign this right away, so you take them out as an open listing, and maybe you're just like dating, right? And now when you pull this puppy out, man, you're going steady. You know what I mean? You're getting engaged, because they agree that they're only going to stick with you. They're not going to cheat on you. You know, you're a jealous lover, you know, however you want to explain it to people. And then if they do decide to buy, and this covers leasing, so that gets a little gobbledygook, but let's just cover sales. If they do agree, they're going to pay blank percent, or however you charge. And you're going to receive that, at the time of the closing. Okay. And maybe, you know, it could be within so many days after termination, then they do buy it. They have little clauses in here that you're still going to be able to have earned the commission. And if there's a retainer fee, some brokers aren't charging them. That's up. Don't ask me what you charge. Don't ask me the amount, because that's fixing. We don't have a standard commission here, and we don't have a standard retainer fee. It's whatever your broker decides. Does your broker possibly have a standard commission? Yeah, sure, because the broker decides. But we in this group together, we're not going to all say, we should all charge. No way, we can't do that. That's against the law. That's a federal antitrust offense. So maybe you don't have one of those. I don't know what you have. Then we go to I'm just doing pieces of it. And then you go to the duties, what the broker is going to do, due diligence list. Many of you have an attached due diligence list that your broker creates with all their concierge services, et cetera, et cetera. And then this is the other potential, the red arrow. Here's the other potential buyer clause. They don't name it that. Other brokers' contracts do. Other boards call it that. But here they say, this is very important. Join me here. The client is hereby put on notice that in dealing with the broker, the client is dealing with one particular agent of said broker. The client understands the broker has other agents in addition to the agents with whom the client is dealing. The client is hereby made aware and hereby agrees that the broker, either through an agent other than the agent with whom the client is working or through an agent with whom the client is working, has the right to present offers to the owner of a property made by buyer or tenants in competition with other offers being made. The client agrees, understands, and agrees that in such case, this is a good part too, that there's no obligation created by this agreement which requires such agent to reveal to the client or to ascertain whether or not other agents are working with other brokers or negotiating on the property. It takes a lot of words. They could have shortened the words, but this is how they did it. And also, we don't have any obligation to tell what the offers are if we know of them. This is really an important part. It's why that Supreme Court case that I referenced years ago in 2005, when it happened, that's why the judge did allow for the plaintiff to prevail, because the other potential buyer clause was not made clear to the client. And let's face it, when you're up in front of a judge, you know what's going to happen. They're going to hold you, the licensee, to a higher standard. They'll raise the bar higher than they would for the poor consumer who didn't understand, right? Let's face it. Now here, I love this. They also do the fair housing thing again. And this is other services not provided. Your broker may provide some of these, I don't know, but this is just a standard form that was made by attorneys at libel. And what they're doing here in this section is really covering you. They're really protecting you here. They're saying pretty much you're not going to do hardly anything, but that's what they're saying. Maybe now you do some of these things. I don't know, but I would say talk to your broker about how their own attorney could take this form and maybe make it more pertinent to their and relevant to their own company. Please do not start crossing out things on these forms, though, because you're not a lawyer and you're not allowed to do that. Remember, Article 13 in the Code of Ethics. Also, it's the law. You're not a lawyer, so don't be a lawyer. And then we have the next piece, all the other, blah-blah-blah stuff that you find in clauses in any contract. Miscellaneous stuff, disputes, how it's handled. I love this. It here now, it codifies that, yes, number 17, that the client signing hereby acknowledges that he's been given a copy of the New York State Agency disclosure form. Yeah, so that covers you double again, right? Let's hope you really did do it. And then you have here, now for those of you who are the buyers too chicken to sign, you tried your best, you practiced, but you couldn't figure it out. It didn't work. You know what? Some will, some won't, so what? Move on. Then you get another buyer. But here, what we recommend in ABR, and we recommend it in CBR, teach both, is that what if you just said it begins today and it ends tonight at midnight? It's just for today. It's just for this showing. But it's just so that we have something in writing that we both can go, okay, yeah, I get that. I agree with that. All right. That at least it's for just today. Or, okay, for today, we'll just do it for today. But let's see how we like each other. We'll go out. We'll see if it's working out. You like me. I like you. We feel comfortable. Then maybe the next time, maybe we'll sign it up for a longer period of time. I would say what period? I don't know. It's not a standard time. It's whatever you guys agree that it would be. Maybe it's based on how much time do they need to find a house, to be in the house, when do they have to live there, etc. But what I skipped is the fee part. And I want to just wrap up with that, but I want to also cover some more things. The fee part, that's right at the beginning. And it's written in here, but I want to paraphrase. I want, so that it makes it more comfortable for you. You get to the part where there's a fee. And they say, well, I don't want to pay a fee. I don't have to pay, right? I'm not going to pay. And you say, yeah, well, let's talk about that. I would jump right to it. If they start with that, I'm not going to say you have to wait till I get to number something. No, go to it. Okay. Let's get right to it. Let me ask you this, I would say to the buyer. Do you think a broker should get paid for selling homes? And they go, well, I guess so. I say, yeah, I agree because, it's fun and everything, but we do get paid. We get paid to sell properties. So I'm asking you this. will you help me get paid? I'm not saying you have to do it the way I do, but that's how I do. And they go, well, I don't know. What do I have to do? And say, well, when I look in the MLS and find homes that are suitable for you, and when I look at listings in my own company, I see what I am going to be offered as compensation through the MLS contracts that these various sellers signed with their brokers. And sometimes that amount is the exact amount that I put right here. Maybe I put percentages, X percent of the selling price. If I'm just using X because, we have to do that. But in your company, you might have a number. So X percent. And if it's X percent being offered, the same thing, then as a convenience of the transaction, the seller is covering my fee. I say, as a convenience of the transaction, the seller is covering my fee. But if it's not that amount, if it's less, if it's zero, for whatever reason, because again, there's no standard fee, I need you to help me get that fee, or else you're going to have to write a check at closing. And I know a lot of people, maybe you have a lot of money, but a lot of people don't have that extra cash. So there's various ways that you can pay, that you can help me get the money. Now, as a caveat right now, we're doing this in 2 seconds, but in ABR or CBR, take one of those. We spent 2 days on this. And you'll practice the scripting. You'll figure out how to use something, the phrases, the words that allow you to be comfortable with these words. And you will find that with your knowledge and your passion, you will have the art of persuasion done. Because the art of persuasion is nothing more than a combination of knowledge and passion. And right now, there's still confusion. I get that because you're newer. Some of you are newer at this. So somebody's saying, well, do you get paid on top of the commission being paid by the seller? I'm going to say this to Janice. On what planet, Janice, let's kid around, do you think someone would get away with that? No. So the seller, it says right in the agreement, if the seller or other people are covering the fee, it will be credited to the commission you owe. So, could somebody want to give you a bonus and buy you a new boat? I guess they could, but we're talking real life. So let's talk about it. The seller is paying this much to his listing broker. And at that meeting, we weren't at that meeting, it's some other broker, they agreed, maybe, that's part of that, whatever part, goes to the person who brings the buyer. So if it's the buyer's agent, the buyer might get that piece, right? If it's agreed upon. So let's assume it was, so therefore what you're going to charge, that X percent, will be paid for or credited to that fee that the buyer owed you, because it's already being paid by someone else. Okay, so if you think people are getting paid twice, that's probably not happening. Somebody said, can the buyer sign multiple buyer agreements, more than one? I like that, Robin. I'm glad you asked that, because in some of the areas in Long Island, they could be working. Like somebody is going to be transferred to Manhattan. They're coming out of Des Moines, Iowa, and they're going to be transferred to work in Manhattan. So they sign an exclusive right to represent with somebody in North Shore, Long Island, near the train to get to Manhattan. Then they sign an exclusive right to represent with somebody on Southern Connecticut, because they can get to Manhattan. And then they sign an exclusive right to represent with somebody from Northern Jersey, from Bergen County, so they can take the train to Manhattan. Or maybe they even come up to Hudson Valley. Maybe they go to Westchester County. So yes, you can have more than one. However, if the same territory, like if you're, Robin's asking that, Robin, in your same town, it would be so wrong to stick a buyer under this unfortunate situation where he's got to pay more than one broker. So you want to ask, this is Article 16 and the Code of Ethics. You always want to say to that buyer, as you're filling this out, wait a second, before we do this, are you currently in an exclusive right to represent a contract with another agent in this general area to buy in our same area? Because if you are, that's going to be a problem, because you're going to have to pay 2 brokers then. So, because they don't know what they signed. Here's the real life. They're going to, well, I don't know. I signed something. I don't know what. Well, try to figure it out, and please let me know, because I'm not here to hurt you. Okay. Just like you wouldn't list a house if it was already listed in MLS. So thanks for that, Robin. Wait, so at the top, you're working with buyers. You're not supposed to cross out the leasing side. I would say ignore the leasing side, right? Because you're not doing leasing. So I don't know about crossing stuff out. You might want to double check with your broker though, and do what your broker says, not what Rosanna Dana said. I just do what my broker says, you know. Let's see if I had another question here. Okay. I think we're okay, but let's get back to the how we handle these commission things. So I might say to the buyer, one of the ways that you can help me get paid is you can authorize me, the broker, the agent, to ask on your behalf that the seller does pay the fee. Now, make no mistake, I'm not suggesting that you build the buyer broker fee into the offer because you're asking for it. You have no right to do that. That's an MLS rule. You have agreed to the compensation offered in the MLS when you make the appointment to show it. You have agreed to that. So you can't be changing the commission. Now, could you have, before showing it, called the listing broker and you agreed, and then they, you know, send you an email, okay, we'll do this, we'll do that. Of course, everything's negotiable. But the minute you make the appointment to show, you have accepted the offer of compensation in that MLS. And if it says 0, you've accepted that. So you better figure out a way to be persuasive with your buyer, get it in writing that, yes, they will help you get paid, or they'll have to write a check at the closing. Now, if Fannie ever changes, and they might as a result of all these crazy lawsuits, if they ever allow the buyer to finance the buyer broker fee, then we'll be in good shape. Auctioneers do that, and they have license like we have, but their buyers can finance it. Our buyers, and there's nowhere on the CD, the old HUD one, to put it, so they can't do that yet. They can ask the seller to pay it. This offer, like it's the buyer's words, this offer includes an X% buyer broker fee to be paid by seller at transfer of title. Or one last thing, and then I do have to wrap it. We could also have something, I've seen this work very successfully. It's not, a lot of these things don't work right now in a seller's market, because the minute you ask a seller to do something he didn't want to do, he's going to go next and take the cash buyer that was offering 100,000 extra. You know what I mean? So a lot of these little like ways or challenges that we're facing about the buyer broker commission are not easily solved in this heavy seller's market. We're more in a transition a little bit now, but we're still in a seller's market. Let's face it. Sellers are getting multiple offers, and they're just taking the best one that's got cash, and they're giving way more than asking price with no contingencies and no inspections. You know what I mean? I get that because we're all in real estate. But when it normalizes, concessions do work. The buyer's asking for the riding lawnmower, and the seller says, all right, or the buyer's saying, I need you to pay my broker, and the seller says, all right, as long as I can sell it. Or the buyer is saying, I need you to pay some of my closing costs. And the seller would say, okay, and they decide how much. Fannie and Freddie rules, if you're looking at the finance part, or if it's all cash, but they still want somebody to help with a concession, they'd probably ask that way. But concessions are not, somebody's saying here, concessions are in place for commission to be paid on top of, as long as, yeah, okay. As long as when you add the broker fee on top of the selling price, as long as that's approved, then we go through the trail with the appraisers, because a lot of the appraisers don't want to fall for that, because what you're doing is you're altering the selling price, not based on market value. You're doing it based on finance. And I know a lot of appraisers who they'll smell a rat on that, but sometimes they don't, it depends. And there's another question of that from Joni. Can we say the buyer agency compensation is X, a portion may be paid by the seller, but you will not go over X? That you're making that a little bit long, but that's what you're kind of saying to the consumer, right? That I'm asking you, Mr. Buyer, to help me get paid. And if I'm being paid as a conveyance of the transaction, but it's not enough to satisfy my broker's fee, because we set our own fee and we're worth it, and let me tell you why, and you better have good reason for your value proposition. If there's a little extra, then what has to happen is somebody has to write a check at closing. Yeah, what else could happen? You could suck it up and not take that whole fee. I mean, you could if the broker says you can and you want to. I don't want to. I have a fee that I believe I've earned the right. I believe I'm worth it, and here's why. We talk about this in these extensive courses as well. The offers of your services, not by downing another broker, by saying, well, because I'm just making this up. Our list to sale price ratio is closer than any other in the median of the MLS, and and our days on market is considerably less than whatever. Truth, not make up and not made up stuff, but prove your value proposition and why you're worth it. Or do what you've been doing all along. You've been working for whatever it said in the MLS. You have positioned yourselves, those of you who do that, as victims of what the listing broker says you're worth. And if you're sick of that and you want to say, damn it, this is what I'm worth, and here's why, and I am going to dig my heels in, then get a representation agreement that allows the buyer to understand, and then dig your heels in. So I want to just go to, I showed you that, to say this to you, and then we'll do a little extra of open questions if you want. Practice, my friends, makes progress. Practice, practice, practice. Take these agreements, role play it at your companies. What if the buyer says this? What if he says that? Then what do I say? What do I say next? So that you can be prepared to negotiate the resistance that consumers have, because they do have resistance. This is a lot of money buying a house. Now, do we have any other questions? Marianne, we don't have a way for them to speak to me, right? They just have to write it?
Yeah, we can't have them come on because it's a webinar.
Okay. Oh, this is not a meeting. This is not Zoom meeting. Okay. Okay. Somebody, Marianne already answered that. Where can we get a copy of the buyer's agency agreement? The buyer broker contract is on your LIBOR site. She gave you the link, but just go to LIBOR and look at your documents on demand. That's where they are. There has been a fear of representing the buyer, not to any foreseeable future that came up that you not disclose unknowingly. Okay, let's talk about, and somebody asked that earlier too. Let's talk about the liability part, because this is something that I think all of you, I know you could leave it, whenever you want, but I hope you'll stay for this. Years ago, when we just represented sellers, we found, and I'm talking now NAR data and also E&O data. I used to sell E&O insurance to brokers. I've done a lot of wacky things, so I know about the insurance part. So years ago, it was buyers suing us way more than sellers. Buyers suing us, usually for misrepresentation. That's always the biggest reason you get sued, misrepresentation. You say something you shouldn't have, or you don't say something you should. They rely upon it. They have damages, etc. There's actually 5 factors. I taught that course yesterday for LIBOR, actually. My light is falling. So the buyers were suing us. So the attorneys at NAR were looking into all of this, and they said, we believe that buyers are suing us more because we don't do anything in writing with them. They call us on our sign, they call us up, they see a house online, they call you and say, can I see it? You run out, you meet them at the house, you do agency disclosure on the hood of the car, and you show them a house. Buyers didn't know, like, well, what am I supposed to do? What are they supposed to do? They don't know anything. They just want to see the house. Now, throughout the transaction, if you do sell it to them, they stub their toe on something annoys them, so they sue you. When really, a lot of those lawsuits that we were having over the years, we were prevailing in them anyway, because they were suing us for something we weren't even supposed to be responsible for, but they didn't know that. Sellers sue us less because we sit down in writing, discuss, the agency agreement, the listing contract, all the details. What if we have an open house? Then what do we do about this? What about when an offer comes in? How do we handle it? What about the key? What about the box? What about the sign? We do all of that. So suddenly buyer brokerage became popular. And what do you think happened in the E&O world, the old Schindler underwriting guidelines that they study? They found that there are now less and less buyer lawsuits against us, because now they smell the coffee. They know the rules of the road. And they're realizing that these are things that maybe there was an encroachment, but that I don't have anything to do with encroachment. I didn't do the title search, and I'm not a surveyor, you know what I mean? But they didn't realize that. So you actually have, to answer the question about liability, you have less liability, my friends, when you do things in writing with the agreements than if you just run around like a psycho with no thing in writing, because they never knew then what you were supposed to do. So my point And the takeaway I hope for you is that the agreements in writing will help relieve that liability because you'll be covering yourself. What else? Even though somebody says, even with a buyer broker agreement, can I start by building my commission into the offer if no commission is offered as a buyer's agent? Donald asked that. Yeah. As long as this is with a discussion and informed consent of the client, Donald, your client decides the rules here. And then you can decide to not take the client, right? But the client is, the client is the principal. So you can offer that as an option. There are many ways I can get paid. One is that I can build the fee into, or the buyer is instructing you. In one way, Mr. Buyer, is that you can build my fee into your offer. So that when we present it to the seller will know that included is the buyer broker fee. If it hadn't been included, Mr. Seller, we would have been offering you less. Okay. But Donald and everybody in today's world, you know how it works. The sellers right now are usually not allowing for commissions, concessions, if you will. But, some of them are. It depends how badly they want to buy the house. Now, last thing that I want to show you, this just came out 2 days ago. I already had it printed at Office Depot because I want to be able to do this when I teach. This is the 2023 Home Buyer and Seller Profile. It comes out the week of the NAR conference every year. So it's November already, but the 2023 book came out. And according to the national data, I'll be adding these slides to my next course. I still have the old slides. According to the data, they're asking this question: how was the real estate agent compensated? And this has to do with buyer representation. 53% of the time, it says they were paid by the seller as a conveyance of the transaction. 31% of the time nationally, 53 was the seller. 11% was they were paid directly by the buyer only. And then buyer, I'm reading this wrong. That's because I should really put my glasses on so I can read. Sorry, guys. Here we go. Paid by seller, 53%. Paid by buyer and seller, a little bit paid by the seller and a little bit paid by the buyer. That was 11%. But hold on to your hats for a minute. 26% of the time, the buyer did pay the commission from his own money. So if you're sitting there thinking, oh, the buyer's never going to pay the commission, well, guess what? 26% of the time, they did in this survey anyway. So get over yourself. Come on. Buyers will pay. There are buyers who say, I get this. I'm hiring you to do a service for me. So I guess it's worth paying you for it. If I was going to buy expensive art and I hired an art broker, that art broker would look all around and find me the art I wanted, and then I'd pay him. So think of yourself as an art broker. You have the art of selling, the art of finding homes. Yes? Okay, now Mary Ann's reminding us, we're having a webinar in December with Jessica Lautz, NAR economist, who will review the buyer and seller profile with LIBOR members and take questions. So if you want to go get this, take out your phone. This is my last hurrah. Take out your phone right now and go to your browser. Go to your browser and type in nar.realtor. That's all you have to type, nar.realtor. Everybody do that? Go to nar.realtor. And you'll see the homepage. You'll see there's like a dog there and stuff that people are holding up a puppy. Go to the right, top right blue bar. That's the ellipsis there with the lines. It's the menu bar. Click on the blue box with the lines. And then you'll see it says real estate topics, membership, third one down, research and statistics. Click on that. Now you see it says research and statistics, market behavior. Third one down again, research reports. Click on that. Now scroll down. Scroll down a little bit more and scroll down to where it says home buyers and sellers. Click on that. And here it is, the book I just held up, Home Buyers and Sellers. Most popular, 23 Profile of Home Buyers and Sellers. That will cost you $19.95 if you want to download it as a member. But if the other ones that follow, all these other ones are free. Animal House, Buyer Bios, the Generational Trend Report is awesome. but at the pandemic, right? Migration, Mind the Gap, millennial stuff, moving with kids, over and over, line after line after line. LGBTQ profile book, Race in America profile book. There's so many different ones, but this is the one. For some reason, they charge $20 for this. But what are you going to do? It's great data. If you're a data freak and you like to have, well, according to the National Association of Realtors, Mr. Buyer, you want to do that kind of stuff, you'll get it from here. It's fabulous. It talks about FSBOs, it talks about sellers, it talks about buyers. And it reminds us of, on this part, chapter 4, how we were compensated. And it does remind us that also 41% of all buyers are signing written agreements, and 17% are doing it orally. So that's not as much. We'd like to get higher stats on that, and you can help. So that, my friends, is really a wrap for me. I want to say, as my last slide here, practice makes progress. Thank you, LIBOR. Thank you, Marianne. Thank you, LIBOR, for bringing me in today. And there's my contact information if you wish to contact me. And that's a mic drop, Marianne. Do you want to say anything?
I did. Thank you so much, Roseanne. And I wanted to let everybody know that Roseanne permitted us to record this, and the recording will be on the resource page that we put in there, or you can just go to lirealtor.com, and under education services, it has webinars, and all the webinars will be there. So hoping that you found this very helpful. I'm seeing all the thank yous, and we will be bringing Roseanne back. 2 of her classes were that she wrote on buyer agency were submitted to the Department of State for approval. We should hear from DOS any day, and we will offer it to our members. So thank you, Roseanne.
Thank you.
Okay. Have a good day, everybody.